rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here today for oral argument in our case number CV19 0032, Jabil Trust versus Phoenix Orchard et al. Counsel, each side has 20 minutes for argument. The appellant may reserve a portion of that time for rebuttal. I would only ask that you keep track of that on the podium clock. These proceedings are being audio and video recorded, so we'd be grateful if you introduce yourself at the outset. We're also being live streamed on YouTube. We've read the briefs, conferenced the case, and are familiar with the issues and arguments, if you keep that in mind when you present. And with that, counsel, you may proceed.
May it please the court, my name is David Abney. I'm here representing a trust for a change, the Judson C. Ball Revocable Trust. Mr. Judson Ball is here with us today.
It's been a long time since we had a chance to talk.
You look familiar.
Yes, Your Honor.
May I ask you to do one thing in your opening that I think will help us great? This case has a long history. There are a lot of facts. It would be very easy to spend our entire 20 minutes on the law. Can you focus us on the facts relevant to the narrow issues we're here for today? Because you can assume that we have a great deal of background in the case, and I don't want to get bogged down on the irrelevant issue.
Well, I understand, and I thought the briefing in the case was fairly good on both sides. Not that I need to stoke the ego of my colleague across the aisle, but I thought we briefed it fairly well. The thing that struck me as I was preparing was the duty issue, and I think it's fairly straightforward, but it's still one I hope the court has clearly in mind. There's a duty to disclose, especially because there's a special relationship here between the main disclosure on the part of the other side, John R. Norton III, or John Sr., John III. It's John Sr., John III is the same in person, who was enlisted by the defendants to provide information to Judson Ball as a trustee because he was a very trusted friend. Also a duty to disclose to correct mistakes. What was disclosed was inaccurate and improper. Duty to disclose if non-disclosure amounts to a failure, to act in good faith and to deal fairly, and disclosure because of superior knowledge. So I think disclosure is an important thing. If the court's got those arguments in mind, we can go on to the next part.
Well, let's talk about, instead of the parameters of the claim, let's talk about the relief that's being requested at this stage. The trust has already received quite a lot.
Right.
So let's talk about exactly what relief you're seeking and why. That was kind of the reason for my initial.
Okay, good. Attorney's fees and costs and incidental consequential damages flowing from the fact that what the trust could have been able to do with its time, attention, and money was diverted to this particular litigation because of fraud.
Why is that a separate claim that we shouldn't assume is already resolved in past proceedings?
It wasn't resolved in the securities regulation aspect of it. It wasn't resolved in the rescissionary aspect of the case. It's the thing that's floating out there right now, which is, well, what assume that fraud, misrepresentation, non-disclosure, some of those things are actionable and happened. What do you do for damages? The attorney's fees and costs is the easy part, but the other thing is you're entitled to whatever consequential damages flow from a tortious act, which would be diversion of assets.
If somebody cheated me out of $1,000 in 1983, and I was therefore unable to buy Apple stock, can I come to court today and say, I'd be a multimillionaire if it hadn't been for that $1,000 you've cheated me out of?
You could certainly try it, but I
could try, but as you are, but would I succeed?
Yes. Well, I'm not trying to say there's Apple stock at issue, but money could have been used
what
in other ways.
specific evidence do you have? In other words, I think you've just acknowledged that perhaps coming in here saying, oh, I could have done something, Apple stock. What evidence do you have that he could have done better than just getting his money back?
Well,
What damage? In other words, what damages are there?
Okay, other than attorney's fees and costs, just setting that aside for the moment.
Set that aside, because I think
Okay.
that's a different issue, and both sides lost on that as far as the award of attorney's fees. And so let's just focus on that issue.
Okay, although maybe I can circle back to the attorney's fees in a moment. What would be the money that was, actually, it's related, money that could have been used for other projects and other items of investment was diverted to attorney's fees
Okay,
and
and I get
costs.
that, but for damages, you have to come forward with more than just, I could have done something else. What else? What evidence is there of that other thing?
Well, we never got that far because we were thrown
We're at the
out.
summary judgment stage.
Structurally,
That
this
wasn't part of the
argument
summary
troubles me.
judgment, as far as I can recall reading through it all.
Didn't the trial court say you also don't have any evidence of damages?
Well, yeah, but that was dicta.
So that's one of your elements,
Well, that
is
was
damages.
That was dicta, though. And there were damages. I mean, clearly attorney's fees and costs in dealing with this contract that it never should have entered into.
But you got your attorney's fees for that portion when the rescission happened.
Part of them, sure.
All of them, as
but
far as that goes. That was resolved. To the extent it was pursued further, the trial court ruled those fees were not recoverable in this case, for either side.
Well, yes, Your Honor.
Don't we
Okay.
have a rule against speculating about what time and money are worth?
You
I
do.
could always say, if only I hadn't gone into public service, I'd be a lot richer. That does not give rise to a claim. I could always say that my time is more valuable if I had used it differently. My money would have been more valuable if I had invested more wisely. But that's complete speculation that finds its way into no cognizable damage.
That is not entirely true. I mean, there can be some speculation. Suppose you were a concert pianist and your hands were mashed.
Then I can
You
assume
could
that-
say, I would have gone to Carnegie Hall. You would bring experts to say he would have gone to Carnegie Hall, would have had a brilliant career, made millions of dollars. And that's not really speculation.
I am not aware of any case, and maybe you can correct me, but I'm not aware of any case that said this person would have been a huge hit as a classical piano player, give them millions of dollars. The speculative nature of that claim is so foundational to the claim that I don't think the law would recognize it. What the law would say is, if you had a gig where you were going to get $5,000 to play at Carnegie Hall, we'll give you $5,000. Not that it was going to launch your career and you were going to be the next Van Cliburn.
I believe there are situations where it happens that you have a special gift or special ability or a special opportunity and it's taken away from
A
you.
key word you said, you'd have an expert come in, you'd have these things come in, and you were at the summary
Right.
judgment stage. None of that was there.
There were reports.
Was there any admissible evidence of $1 in damage beyond the speculation that he might have put it someplace else?
There were reports in the record. And
The reports were, as I recall, were unsigned, and they were just attached to an unsigned, unverified disclosure statement.
It may not have been the strongest evidence in the world,
But
but there was evidence.
But it needs to be admissible when you're at the summary judgment stage, and they're saying you don't have evidence of damages.
I
Isn't that true?
understand that. However, besides attorney's fees and costs, which is a legitimate item of damages under any circumstances, there was evidence presented about
But
losses that were
attorney's fees and
sustained.
costs in pursuing this claim of the misrepresentation isn't a recoverable damage. That's something that you can get after you establish your claim. The attorney's fees aren't an element.
I don't even think you can do that.
Well, it depends on
We
the...
wouldn't need 12.341.01 if attorney's fees were just generally recognized as an element of damages.
No, but in this particular case, what are the damages flowing from the tort? The tort is
That's what I
fraud,
want.
and that the tort is getting you into this contract that you shouldn't have been in at all. I mean, you could get you don't get attorney's fees for what they did, which was fraud, misrepresentation that landed the other party into a bad contract, like the Morris case. They don't get attorney's fees for that. But look at it from the flip side. Look at it from the side of the entity that got into the bad situation, that got into the bad contract. It expended attorney's fees and costs because of getting into that bad
But the
contract.
American rule, which is what it's known as, is parties bear their own fees unless you can provide us to a fee shift down the street, the legislature, or in terms of a contract, isn't it?
normally, but this is not the normal, this is not a normal kind of tort situation. This is a
Any case
tort.
that says in this situation, and there are a lot of cases like this out there, that the attorney's fees alone supports, and costs support damages or negligent misrepresentation or fraudulent misrepresentation.
I don't know if any were cited to you. If the court will give me an opportunity, I can cite some to the court, but
I
the
suspect
briefing
that
didn't
there
go
are.
that way.
Mr. Edmund, you do a lot of tort work. This is a fairly garden variety tort. It may involve a higher level of scienter than the red car, blue car case, but it's a tort. You don't allow damage recovery in tort. And saying that there were opportunity costs associated with this expenditure of money on attorney's fees can't work unless you're saying that somehow investors deserve to be treated differently from anyone else.
Well, let me give you a two-part answer. First of all, sure, in the usual tort case, you don't get attorney's fees and costs. And that's why they don't get attorney's fees and costs. But this is not your garden variety tort case. You don't usually have a tort case that says you committed fraud, and as a result of that, I got involved in this contract I shouldn't have been involved in at all. It's usually you committed fraud and I suffered direct, immediate damage because of that.
That sounds like an average Tuesday here.
Now,
We get those cases all the time.
well, I hope it's a Wednesday, because on Wednesday, maybe we can say
How is, I don't understand how.
I want
Sorry.
to hear your answer.
I know, maybe I'm parsing things very tightly here, but that's really my job in a case like this. This is a different situation. You're saying, what we're saying is, it's not your typical fraud case where you commit fraud and I suffer immediate damage of some kind, to reputation or whatever it might be. This is where you commit the fraud, and because of that, I get involved in this contract. And then in the course of dealing with the contract and all the problems that causes me, I expend a whole bunch of attorney's fees and costs in the course of dealing with that.
So it's a fraudulent inducement case.
Oh, yeah, sure.
Okay. Is there any law that says you get fees as an element of damages in a fraudulent inducement?
I don't think the parties have briefed it and approached it in that case. But like I say, if the court will allow me supplemental briefing, and of course my colleague across the aisle,
What
I think
about
I can supply some precedent on that
Your
particular point.
initial reaction was, it was I think you used the word dicta, that the damages portion of the Superior Court's minute entry was dicta. Can you provide some, how do you reach that decision, and how do we reach that decision?
Well, it wasn't, the judge decided the case by saying, I did not find any fraud, misrepresentation, and so forth. There was not evidence to support the fraud, the misrepresentation, the non-disclosure. That's what I find, and you're out the door on that. And all the rest about the damages, which dealt to a great deal about the quality of evidence that was provided on the lost opportunity kind of thing.
But it's an element of the claim. At that point, summary judgment, you're talking,
Yes.
give me evidence on each of these of these elements, and so I don't understand how that's dicta.
There's a yes, but it's dicta on that there are in fact damages, and it's the damages I was trying to explain, namely the damages dealing with this contract I got involved when I didn't want to get involved in a terrible contract like that, and I wouldn't have gotten involved in a terrible contract like that if they had just been honest with me about these mandarin oranges, which are unsuitable for cultivation in the way they said they were.
Okay, so you got in a bad contract. You still need to show the damage from it.
Right.
And I'm still struggling to hear what evidence. Now, you made reference, for example, in the piano player case, to the expert who comes in and says this is what it would have been.
Right.
What I understand the record to be is an unsigned document attached to a disclosure statement, and maybe one example where your client said, oh, I could have gotten 40% return on investment without any documentation, reference, or support for it. Those are the only two pieces that I've heard. How are they not purely speculative?
Well,
and inadmissible?
Well, the client's testimony that it would have gotten more money is admissible. It's weak, and I would want to bolster it considerably. But if you come in and
But how can you have to have admissible evidence that the jury can make a determination? I could have made more money.
What you're talking about is weight and credibility. I suspect that you're giving it little weight, and I suspect that you're finding...
Or is speculative.
We don't deal with
Well,
weight and credibility here. This is
Exactly.
not a weight and credibility court.
Exactly the
What
point.
I want to ask you, I'm just trying to make sure I understand your theory correctly. If my stockbroker tells me, hey, invest in Global Crossing, you're going to make a killing, and I really deep down wanted to invest in Microsoft,
Yes. Mm-hmm.
and it turns out Global Crossing wasn't such a great idea, right? Because it went bankrupt during the one of those recessions, and I bring my claim against my broker because in fact my broker had a conflict of interest, right? So I win my claim because my broker shouldn't have been giving me that advice. Are my damages the money that I lost investing in Global Crossing, or the money that I would have won or would have made investing in Microsoft?
I don't see why you can't ask for both, but
Well,
as
you
far
can
as
ask anything, but is a court ever going to recognize the latter theory as valid? Because I think not,
yes,
and I don't see any air gap between your theory and that case.
yes, of course. Well, pardon me for saying of course. That's a silly thing to say to any court, but yes, I believe that you would have the right to say I was going to. I've got 12 popes and bishops and rabbis in the room, and they say he told me he was going to invest in Microsoft. He kept saying I'm going to do it. If my broker had not steered me wrong,
So
I would have invested in
let's say we get to
Microsoft.
that point, and we establish now that even the other side is very candid, and they say we agree he would have invested in Microsoft.
Right.
So what? Does that tell you when I would have sold? Does that tell you that I would have actually made money on the investment? All of that is complete speculation.
No,
What
whether
the
you
law usually gives us is what we lose,
What
not
you-
what we what might have been.
well, in your example, what you would have made is a matter of fact, based upon what's on the stock market. You could say, and then you could provide testimony.
Maybe I would be greedy, watch Microsoft peak, watch it tank, and say, boy, if I had sold when it was high, things would have been a lot better.
That's a fertile field for cross-examination, is what that is. But your testimony yourself,
Fertile
I would have
field for
held it.
wishful thinking, which is pretty much what makes the market run, but it's not really something courts get involved in.
Well, if you come into court and say I would have made 40%, I was going to make 40%. It goes to weight and credibility whether anybody believes that or not, and as you say, that's for the jury. But if you come into court in the Microsoft example and say, I would have invested in Microsoft, everybody's willing to buy that, and I would have held it for 5 years, and then my plan was to sell it, that goes to weight and credibility of your testimony. And then all you have to do is look at the stock spread and the stock information in the Wall Street Journal to figure out how much you would have made, and bring a CPA in to deal with the tax consequences.
This reminds me of a case I had as a trial judge, and the jury gave somebody $450,000 because his truck got damaged, fender. But he claimed that for the next 5 years he had this great business plan that was thwarted by this fender bender.
I hope that verdict survived.
Well, it wouldn't have survived the settlement that eventually run, because I was in the process of writing the order vacating it and 13th juring it at the time. But I didn't see any legal basis then, and I don't see any legal basis now for that sort of speculative opportunity cost argument. Is there a case I should read after I get off the bench today?
Absolutely, and I'll find it for you. If you would
don't
just
have it?
not in my hip pocket.
Okay.
But let's just finalize one thing. What was never offered was even the business plan or the Microsoft stock purchase. No evidence of what the actual return would have been was offered.
Well, there was
that
the little bit that you have described, and
and not inadmissible.
I think the testimony from a witness saying that I would have made X number of dollars is admissible, but then you're back in weight and credibility. And at that stage, the jury has to decide.
So that's the only piece that you would rely on.
That's a solid piece of evidence.
Okay.
So I would rely on that. Thank you.
Thank you, Mr. Abney.
Good morning, members of the panel. My name is Sheldon Freeman. I'm here representing the defendant, Mr. John P. Norton, both in his individual capacity and as executor of his father's estate, and Mr. Roger Stevenson. And Mr. Norton and Mr. Stevenson are present in the courtroom. Before I address counsel's comments, does the court have any questions they'd like me to address?
Well, would you agree that the scope of this appeal is as Mr. Adams described it?
Yes, Your Honor. I guess it was our position initially when we filed our deck action for the rescission that made his client whole and we should be done. The trial court disagreed with us and said, oh, you can get any other damages that it would take to make you whole in the position you were before the contract.
Well, I've been pretty hard on Mr. Evans describing the potential problems with an opportunity cost theory. But that's because I'm not aware of any law supporting it. I'm also not aware of any law against it.
Well, that's interesting, Your Honor. You say that. If you look at the rescission statute, this issue's been decided. Rescission provides for return of capital, less any distribution.
This is a different claim. This is a negligent misrepresentation claim.
Well,
not a rescission.
Well, opportunity cost, though, comes from the loss of use of funds. And the idea of the statutory rescission is to put the purchaser of that interest back where they were before they started, before they invested. And if they had an argument that the 10% interest that he did get, which almost doubled his return, was inadequate because it didn't reflect, hey, I would have made more money than that, that was his opportunity to do that.
Well, where did okay, that's a good point, and I warned everybody that we knew every fact about the case cold, but I may just prove myself wrong. What was the basis for that 10%?
Your Honor, it was a statutory rate, and we actually did have an argument about that, of whether he was entitled to the statutory rate.
Okay, so it wasn't his theory that his investment prowess was generally a 10% a year kind of thing. It was the application of the old statutory rate.
Correct.
Okay.
Correct.
So, counsel, if I pull up the motion practice on summary judgment, all these things you're talking about now on damages, are those arguments that you made in the trial court?
In terms of
Well,
our arguments on damages were, yes, we argued this made him whole. He got all his interest, he got interest back, so he got his opportunity cost back. We asked for declaratory relief that we're done with this case, because that was the whole idea.
So the
Instead
dicta-
of being here 4 years later.
so you would disagree with the dicta argument that the court reaching the issue was not argued, it was just sort of plucked out of the air?
Oh, completely, Your Honor. It's not dicta. It's right here in the minute entry. Judge Thomason said there is
No, I'm saying it was argued, right? There was an issue clash.
Absolutely, yes, it was argued.
Okay,
I mean,
thank you.
because what you see, Your Honor, I think it was Exhibit 19 to our motion for summary judgment, is this spreadsheet that is a listing of numbers that he claims, that the plaintiff claims, they were entitled to as additional damages. Well, you'll see in the briefing, our analysis went through, well, they're including fees that they already applied for in the initial rescission calculation. So they've already been determined. There were fees from the derivative case in there. There's no basis to recover those as part of his damages. It was our position, Your Honor, when we did the rescission, he's done. Let's capture whatever's left, make him whole, and be on our way. And instead, we've had to spend hundreds of thousands of dollars dealing with 2 different appeals, a petition to the Supreme Court, now this appeal, a lengthy summary judgment motion, all on what? On allegations that weren't true?
That's not really for us to focus on, is it?
Oh, it is, Your Honor. In our cross appeal, we brought up the 349 argument, and that most of the allegations in this case were, I read the offering memorandum, I relied on it. I had extensive conversations with Mr. Norton, and Mr. Stevenson about this before I invested. And then he comes back at his deposition and says, I never talked to Stevenson. I never talked to John P. Norton.
I understand, but this court isn't empowered to decide who is telling the truth.
No, Your Honor. My point being is that he, as we've argued, he unnecessarily expanded the proceedings by these types of allegations, and then coming out in his deposition saying, yeah, I never talked to him. So when we look at the context of this, I think Your Honor focused in on the scope. It's a very narrow issue that we're left with, and it really is, what does it take to put him back to where he was before he made this investment? End of story. The lost opportunity cost, to Your Honor's points, it was a one-page document attached to a disclosure statement, unauthenticated, that he had made some returns and other real estate investments over the past like 15 years. There was no backup to it. There was no other documentation to support it. And it also omitted the fact that his last two investments that were the most recent, which Mr. Norton was invested in, lost everything. So, I mean, they talk about this investment being a failure, which, by the way, Your Honor, those mandarins are still in the ground. They're being produced. And so this isn't a case where the project didn't go forward at all.
So just to be clear, you're, aside from your cross appeal, your argument would be that this appeal can be resolved on damages and move on.
Yes, Your Honor, I believe there is no admissible evidence of any representation. Most of it came from his later declaration that completely contradicts his deposition testimony. But if you look just at his deposition testimony, he says, I had a lunch with John Sr., like I always did. Near the end of the lunch meeting, he shows me the executive summary. I'm a speed reader, so I scanned the first few pages, so at least he thought I was interested. And I said, yeah, whatever you want, I'll write you a check.
That's going back to the claims and the misrepresentation. I'm asking on damages.
Yeah.
Your argument is that that's dispositive here, that's the sole issue that this court needs to address.
Well, you raise the other issues, correct?
I have raised the other issues,
You
but
raised
you're right.
them, but-
To the extent this court determines there are no other damages based on this record, yes, Your Honor, we're done.
And you would agree to withdraw your request for attorney's fees if that's how we were to rule?
From below, we would withdraw the cross appeal. We have requested them for this appeal, but yes, Your Honor, we would withdraw our request. And frankly, to the extent the motion for summary judgment is affirmed, we will also withdraw the motion to dismiss. So, but yes, our position is he's been made whole. He's not entitled to any damages, and there is no admissible evidence in the record of any additional damages. And Judge Thomason, in ruling on the summary judgment, specifically found those items to be the case. So, unless Your Honors have any other questions for me, I'll be done. Thank you.
Thank you, sir. Thank you, counsel. Mr. Abney.
It's one of those rare cases where I'm thinking of not doing a rebuttal. Are there any questions from the court at this point?
You may have answered it already. It just seems to me that your theory is based on this notion that money is not just dollars and cents, it's all the potential that it represents.
Exactly right. That's the American way.
Except whether we've been on the gold standard or not, we've always valued a dollar as a dollar. And that's why we have this concrete measurement of wealth that we exchange, because it's something that we can, if you offered to sell me a car, I'm not going to give you, $10,000 and all you could do with it. I'm going to give you $10,000 because that's the agreed upon price.
Yes, Your Honor.
You would think that if money represented something much greater than its actual numerical value, that the law would be just overflowing with cases that talk about that. And yet I'm nearing the end of my career and I'm not aware of one.
Well, as I say, the briefing didn't focus on that, and if the court has any doubt about that particular issue, certainly we can do a supplement. I did it recently in another
But
case.
between the two of us, we've got to have close to 100 years in this game, and neither of us have heard of a case that does this. Isn't that telling?
It's just.
Yeah, I have a Westlaw password, and I'll check.
Yes. I believe that if you went out with your $10,000 and bought a lemon that somebody fraudulently sold you, and you could have used your $10,000 to buy a classic automobile that went up in value to $250,000 at auction the next year, I think you'd be entitled to get the difference in damages.
It's a beautiful vision to assume that everybody's life will work out perfectly, but for the one thing we're in court about. I'm not aware, that that's even practical, because if you adopted that model, what would we get? Rapid deflation? We would expand the amount of wealth in the world exponentially if the law said everybody is a winner.
Well, there should be proof, and no question about it. And what the weight and the credibility to be given to the proof is really the question. But yeah, just a general comment, if I may, money is a fiction, quite frankly. If we had some horrific event happen in the world, an atom bomb on Washington, D.C., for instance, the value of the money in your pocket would go down to about zero. So, I mean, it's just a fiction. But the important fiction here is whether you can prove to a jury that you could have had different result, different amount of money if you'd invested in a different project. I've used my time. Thank you, Your Honor.
Thank you very much, Mr. Abney. Thank you both, counsel, for your argument. We will take it under consideration, and with that, we are adjourned.